It is my pleasure to introduce our next speaker. David Spector is a litigation partner with Akerman in Florida. He's recognized by Chambers USA and is listed in Best Lawyers in America and Super Lawyers for commercial litigation and labor and employment. He is a frequent presenter on labor and employment and other topics. He is active in pro bono work and in several bar and trade associations. He has more than 20 reported decisions and maintains an active practice in commercial litigation, professional liability defense, and employment litigation. Here to speak to us about a witness's Fifth Amendment privilege, please welcome David Spector.
All right, so before I watched Hugh assert his Fifth Amendment rights up here, I was going to start this presentation by recalling how 25 years ago I first heard of the Fifth Amendment when I was in a high school class, and then realized how significant it was as I and a group of friends walked out of a 7-Eleven while we were in high school with a few alcoholic beverages to be confronted by our local sheriff. So you realize now that what you learned back 25 years ago actually has a play in what your life may bring later on, but Hugh's assertion of the Fifth here will be a much better and apropos topic than my little interaction when I was in high school. So let's talk about the Fifth Amendment for a moment. So we all know that in a criminal case, you cannot be called to testify and incriminate yourself. The Constitution actually provides for that in criminal cases. It says nothing about civil cases. So what happens when you're in a civil case and either a non-party wants to take the Fifth or your defendant wants to take the Fifth? So let's walk through it. All right. So first of all, the Fifth Amendment, just briefly, they're not without boundaries, okay? So first of all, it's a personal right. You, as that person, have the right to assert the Fifth Amendment in a civil case. Corporations do not. Corporations, trusts, labor unions, etc., they have no Fifth Amendment rights. That is a purely personal right. Lawyers, you cannot assert that privilege on behalf of your client. You can whisper in the ear of your client. At my last trial about 4 months ago, I had a defendant take the stand who had asserted his Fifth Amendment throughout the trial, and his lawyer literally sat right next to him, leaned down and whispered in his ear, which the trial judge, a federal judge in Miami, allowed. It was fine by us because the jury was sitting 4 seats away and got to hear his lawyer tell him every time in another language to go ahead. And at times during the trial, they would have a little bit more colloquy in a foreign language, and I would just sit there and stare at them. But the point is that it is a personal right, and the Fifth Amendment does not prevent you from finding information out which may incriminate that person if you find it out from another source. So if you subpoena it from another source, if that defendant made a comment to another third party, the fact that that's incriminating, tough luck to them. All right, so what does it mean? First, you have to have a reasonable fear of incrimination. As the United States Supreme Court said many years ago, it is reasonable cause to apprehend a real danger of incrimination. So when you look at the case law, and the case law in the Fifth Amendment in civil cases is all over the place. There is very little consistency between circuits. But it has to be real and appreciable. So the first category is always, well, what happens when you ask that question during deposition, sir, and we do a lot of fraud investigations, sir, isn't it true that the time you submitted that application for insurance, you knew that fact to be false, right? If they answer it, that's crime. So that's pretty easy. We know those. But what about where it's not so obvious on the face of the question? And in fact, it creates the link between other pieces of information. So what if we could prove, what if we could ask a question of a witness that would show that they had possession of certain information that would connect the other elements of a criminal enterprise? Those are the type of cases where the courts have held that that is a real and appreciable fear of being incriminating yourself, and you do not have to, in a civil case, provide that link, and you can assert your Fifth Amendment. Very frequently when we file cases, we will get an initial motion to stay, and the other side will say, hey, wait a second. Those facts, if true, will prove up a criminal enterprise. Well, the reality is that may be true, but most trial courts, and we're going to talk about a stay later on, won't stay it because it's not so much that that the facts could necessarily create risk of criminal prosecution. There doesn't have to be actual prosecution going on. Law enforcement does not have had to have made contact yet, but but the fact that it could happen in the future is a factor that the court will consider in granting a stay. So when, in your case, in your civil case, can this be raised? First of all, it can be raised in an answer. So if you are a defendant and you need to raise the Fifth Amendment, you can't. What do we do with an answer? Right? We either admit, we deny, or say we're without knowledge. Well, what if admitting actually would implicate that person in a crime? You can assert your Fifth Amendment in response to that factual averment, and that assertion of the Fifth, though, will not be an admission of that fact alleged later on. Obviously, you can assert your Fifth Amendment rights in discovery, answers to interrogatories, obviously at depositions, which we're going to talk about, and in response to requests for production. Similarly, you can assert that at trial. And we're going to talk a little bit later about what happens at the end of a case when you are the plaintiff and you want to put that guy on the stand who has asserted his Fifth Amendment rights throughout your case, and whether or not you are allowed to parade him in front of the jury and make him answer every single question that you want. And I'll show you a little bit what happens then. Blanket assertions. It is not infrequent that we will receive a letter from a criminal defense lawyer who for a non-party who we want to depose, and we will say, we intend to insert our Fifth Amendment rights to every single question you ask at that deposition pertaining to your fraud scheme. The law is very clear that blanket assertions are not permitted. You may not instruct your client to ahead of time basically say, hey, I'm going to say the Fifth to every single question, so therefore I shouldn't have to be deposed at all. The courts require a case-by-case, question-by-question analysis as to determine whether or not the burden which bears by the person moving forward on that privilege has been met. All right, so let's talk about what happens. You got a person that takes the Fifth. They do it throughout discovery. They do it through your answer. We can talk a little bit more about that. And you roll towards a trial, and you are going to ask that the court issue an adverse inference instruction. The adverse inference instruction is an instruction to a jury or trier of fact. It happens rarely, but it happens in bench trials because most judges know how to deal with it, which will instruct that jury that generally the answer to that question would have been favorable to the person who had asked it, to the other side. All right, so it's very clear that unlike criminal cases, an adverse inference may be drawn. Generally stated, it had to be given, it would have been unfavorable. Now, some courts tweak that. Some courts say it's not that it would be unfavorable to him, rather it would be favorable to the plaintiff, so if you're a defendant. Whatever the iteration is in your circuit of how they handle it or in your particular judges, at the end of the day, it is an instruction to the jury that, in fact, that question asked would have been favorable to the person asking it. But to do so, you must show that that person had personal knowledge. You cannot get an adverse inference if you do not lay the predicate or foundation through their testimony or other circumstantial evidence that, in fact, they actually had knowledge of that. So you can't go in and ask questions that are kind of out there with no factual predicate because you're hoping to get the person to assert the Fifth so you can rely on that in the case. Court's going to require you to have laid the factual predicate that they were involved in the scheme, there was enough information to connect them, that in fact they had personal knowledge. You also cannot get an adverse inference instruction to a jury unless you can show that you have other evidence to corroborate their involvement. In other words, you don't get to roll to a trial with the only evidence you have with that person taking the Fifth Amendment. You got to do your homework in the other parts of your case and put together the other pieces to the puzzle to show that even without that, you would have enough to get your case to a jury. Now, why is it that courts allow for this type of an adverse inference? And obviously, for those of you that haven't had a trial with it, it is a death knell to a defendant to have to take that stand and take the Fifth Amendment. I mean, it is crushing. And when you watch the jurors' faces, when that person repeatedly, question after question, asserts his rights against self-incrimination. And in my last closing, where the defendants had taken the Fifth Amendment, I walked over to in front of his table, and when I was explaining to the jury that we want to know where our money went to, and it was $5 million of insurance proceeds, and he had the opportunity to stand before this jury and explain it to you where the money went and why he did what he did, but he chose not to because to do so would incriminate him in a crime. I mean, that is a tough blow to a defendant to overcome in a civil case. So the reason why the courts allow it is because we will not allow in our discovery scheme someone to use the Fifth Amendment as a weapon in their case and hide behind it. So if you are a defense lawyer and you're in a civil case and you are going to use the Fifth Amendment and you are going to cripple the plaintiff's ability to prove up the actual facts of what happened, understand that the courts are going to allow that invocation to come in. Now, in the case that we cited, it was a civil forfeiture action by the federal government to seize proceeds as a result of a drug trafficking scheme. Prior to trial, the defendants had asserted the Fifth Amendment and the government moved for summary judgment. And after the government did, the defendant said, well, hold on a second. I don't want the Fifth anymore. I'm going to answer. And the court said, no way. All right, your attempt to then withdraw it, we are not going to allow that, because that plaintiff, in the case of government, had gone through a year of discovery and had the Fifth Amendment asserted at every spot, and now we're not going to allow you to retract it after discovery is closed. So you have to assume that once it is asserted, you are stuck with that Fifth Amendment for the duration of that case. Now, what happens if a third party asserts it? There is great case law that says that you can get an adverse inference instruction to a jury even if it's not the defendant. And here we've listed a series of cases, and it's in our materials, where it's just a close relationship. There's a Second Circuit case called Labouty, which is really the preeminent case on when you can get that for a third party. But in all of these circumstances, the courts determined that the relationships were so close, that the interests were so aligned, that these third parties who took the Fifth Amendment will cause an adverse inference to be instructed to the jury, which will be unfavorable to the defendant. So it's a very powerful tool, even when the defendant themselves does not assert the Fifth Amendment. And here's a case from the Southern District of Florida. The same judge that we tried our last trial before, and in this case it was part of the Rothstein's Ponzi scheme, which was a lawyer Ponzi scheme that TD Bank had been sued for. And as you can see here, the court instructed the jury that you can infer from Mr. Spinoza's answers, a personal right for him to invoke the Fifth, that would be adverse to TD Bank. So your employees, their assertion of the Fifth can come back to bite you in a case where your entity, has been sued in connection with the scheme. Waiver. So you want to answer the question, you give a little bit of an answer in an interrogatory, you answer 2 questions in a deposition, then you say, nope, I'm done, I'm not answering anything further.
Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite. 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not.
Now, Representative Gowdy is a former DOJ prosecutor, a very well-accomplished trial lawyer. So, in these proceedings, he was very well accustomed to dealing with assertions of the Fifth Amendment after someone had previously answered their 17 different assertions of fact to support their case. So let's talk a little bit, what does really waiver considerations mean, right? You can waive them how? Interrogatories, requests for admissions, depot questions, and in fact, producing documents in response to a request for a production. And we're going to talk in a second what it means to invoke your privilege by the mere act of the production of documents. So generally, the law is that once a witness answers some questions on that particular topic, he will not be allowed to assert the Fifth Amendment subsequently on the very same topic. But again, this is a very fact-by-fact, case-by-case inquiry, and the courts are kind of, again, all over the place. The court has to make a determination whether further questioning, additional questions, would subject that witness to a real danger of now being incriminated. The Ninth Circuit in the In Re Master Key litigation came up with this great, well, I wouldn't suggest that it's great, but it is certainly effective in our civil cases, that a witness can pick the point beyond which he will not go and refuse to answer any questions about a matter already discussed, even if the facts already revealed are incriminating, as long as the answer sought may tend to further incriminate him. Frankly, being a plaintiff in fraud cases, we disagree with that because we feel that once the defendant has made an intelligent choice with counsel sitting next to him to answer a question in the context of the discovery process, we should not be foreclosed at that point from further exploring that and doing it at trial. The Ninth Circuit has a little bit of a different view. The cases that we cited in the proceeding, in the papers, will show you that it really is very fact-specific. Have the circumstances changed? What has happened since that witness gave their initial testimony? Are we now in a different stage? Has law enforcement all of a sudden surfaced and have subpoenas, criminal investigative subpoenas, been issued in the interim? All of these are going to be factors as to whether or not a waiver has occurred. So let's talk for a moment about collective entities. There is a collective entity application. There's a theory where the Fifth Amendment does not apply, no matter how small, no matter how large, to corporations, trusts, partnerships, etc. It is a purely human privilege that an individual gets to assert. The law will tell you that a representative of a collective agency cannot invoke the Fifth to avoid producing documents, even if they may incriminate himself personally. Very recent case from a few weeks ago, Bank of America had sued to collect on a promissory note and had received a $35 million judgment in its favor. And in post-judgment discovery, sought documents on a trust that was going to relate to the production of tax returns that the trust had created during its operation. The court held that the production could have been deemed a testimonial act because production would establish the existence of tax evasion. The court will look at the underlying documents that are to be produced. And if the underlying documents would show knowledge of someone, which would be an element of a crime, or active participation perhaps in tax evasion or another criminal enterprise, the courts can hold that the actual production is testimonial in nature. But in the Bank of America case, the court said, well, that's all good and fine, but because it's a trust, it's a collective entity, and a trust doesn't get a privilege. So as a result, those documents had to be produced by that individual, irrespective of whether or not they may tend to incriminate them. So judicial accommodations, we talked a little bit, you heard earlier in the presentation about stays. Courts will consider staying civil cases. Federal courts will when the Fifth Amendment may be invoked in the future. And the Ninth Circuit here, which has been widely followed, has a 6-point test to look at whether or not a case in fact should be stayed. The most important factor is really number one, the extent to which the plaintiff's Fifth Amendment rights are implicated. The rest of the factors kind of fall off if you read the cases, and the courts really don't focus too much about interests of persons, not parties to the litigation. The key issue will be, what has that person done that will cause them to invoke that Fifth Amendment? And if, in fact, there's been already criminal inquiries, prosecutors have been swirling, there's been other parallel proceedings, then, in fact, the first factor will become much more prevalent, and the court will consider staying it. But it is very frequent that, as I heard a district court judge say to us recently, you know, if I had to stay every single case in the Southern District of Florida because there was a risk of criminal prosecution, we would have no civil trials here in Florida. So it's a real problem, and many courts that are faced with a high volume of schemes, civil cases that involve criminal implications, recede away, and they will not grant stays. It will be very dependent upon your jurisdiction. So lastly, let's talk just very briefly about what happens where a trial. And in our case, we were able to convince the judge that that defendant should sit on that stand and they should answer every single question I want to ask them that is within the realms of relevancy as to the fraud scheme in front of that jury. You'll see here that there are cases that go around the country where certain times courts will compel defendants and other times the courts will not compel defendants to do that and simply will instruct the jury or will allow a deposition where they took the Fifth, not live, to be pled before the jury. The FDIC case is important because there a court refused to adopt a categorical rule to bar a party calling as a witness a non-party who did not have that special relationship for the purpose of having that witness exercise the Fifth Amendment right. So if you have a non-party, even though they're not aligned, okay, you still have the right to call that person to invoke their Fifth in front of the jury in connection with the scheme. So that is a very quick overview of the use of the Fifth Amendment. Hugh is going to have some problems here today. So Hugh apparently, according to my esteemed colleague Phil, had as a check, right, that was written, that was for $10. Hugh will be required to now produce that check because the act of producing it is not testimonial in nature. He should have thought of that before he made a bad bet and picked the wrong team to win the Super Bowl. Thanks very much. Appreciate your time.